Thank you. Everyone else can be seated. All right, so at this point in time, I'm going to read the rest. Mr. Davidson by Mr. Bose.
You ready?
Are you ready?
All right, remember when you were asked by Mr. Berry whether you were aware of any other instance in which the method you used in this case, the market approach, was used for a single web posting?
I am aware of that statement you made, yes.
This is a unique situation, isn't it?
Absolutely.
Are you aware of any other valuation expert being asked to value the increase in a website's value based on the posting of an explicit sex tape?
I've never heard of a situation like that.
You were also asked, and I think you said that you were not aware of any instance in which a website was valued based on traffic. You recall that?
Aside from the website valuations that I've done, but publicly available, yeah, I do recall.
Can you play that clip of Mr. Denman, the third time?
When you invest in an entity, how do you determine whether it is working or not?
Usually audience is the measure that I look at first.
And how do you measure audience?
Currently through a service called Quantcast, formerly through a service called Sitemeter.
Are you aware of another one now?
I am.
You were also asked, I think Mr. Berry pointed out to you that during 2012 there were 100,000 posts on the Gawker Media Network and 10,000 posts on Gawker.com. Do you remember that?
I do.
Do you know how many of those were a post of a sex tape?
To my knowledge, only the one.
Do you remember being showed, it was Defense 137. Remember being showed this graph?
I do.
And I don't think it was in this form, it was blue, but you were showed those two peaks. You recall that?
I do.
And the second peak in October of 2012 was the time period that you had identified as being related to the Hogan sex tape, correct?
Correct.
And then that first peak was in September of 2012.
Right.
And I don't think you knew what that peak was attributable to, did you?
I believe it had something to do with royal breasts.
Can I approach the witness, Your Honor? John, can you pull up E7? What's the date on the Kate Middleton piece?
September 14, 2012.
So that would coincide with that first spike that we saw on the chart that you were shown?
Yes.
You were asked some questions about comparables, and I think the first two you were asked about were grandparents.com and yelp.com.
Correct.
You remember that?
I do.
Are those both content-based websites?
Absolutely.
And then you were also asked about some of the other comparables you used, I think, that weren't publicly traded companies, Bleacher Report.
Right.
Is that a sports site that's similar to Deadspin?
It is.
And then you were asked about a few of the others you would use. I think BuzzFeed was one of them.
Right.
Can you play the clip of Mr. Denton, page 129?
Who do you consider your online competitors?
No, it's a rapidly changing landscape, as I'm sure you know. And we have direct close competitors such as BuzzFeed. But I'd look at Twitter, Tumblr, and other information networks as being probably larger threats to our existence, models for our emulation.
BuzzFeed was one of your comparables, right?
Yes, it was.
And when Mr. Denton talks in that clip about information networks, would that be content-based websites?
Absolutely.
And all the comparables that you used are content-based websites, correct?
That was one of the criteria for picking those comparables, correct.
Pull up. I looked at this article a few times, and I just want to make sure we're clear on something. Because you were asked about a number of questions about unique page views and unique viewers, and I think what you testified to is that some page views are worth more than others. Is that right?
Well, yes, in Mr. Denton's own words, that's absolutely true.
And in the next quote here, one of the things that Mr. Denton talks about is in the context of page views, some page views being more than others is an exclusive.
That's correct.
John, can you bring up the one? Can you zoom in on the top two stories in that chart in the bottom? Can we get that bigger? Got that blue, does it have that version you showed? The blue? Does he drop off? Yes, that. Thank you. You just zoom in for me, please, Tim, on the top three stories. That's good. Yes. Thank you. The top item on this is the home page, right?
Correct.
And then what's number two?
The Royal Breast or Topless Kate Middleton story.
And then what's number three?
The Hulk Hogan sex tape.
So when you testified earlier today that some page views are worth more than others, is that what you were referring to?
Absolutely.
And to your understanding of those exclusives?
Yes.
And I think when you were being asked about unique page views versus unique viewers and why you used one as opposed to the other, I think that you had testified that there was some data that was not available. Is that right?
Yeah, we asked for a lot of different data, and much of it was not provided to us.
Can you play that clip, please, Mr. Kidder, at page 112?
Gawker Media maintains a lot of information about how its viewers, readers behave. You indicated in your initial answer to this series of questions, though, that you did not maintain records with sufficient granularity to permit you to quantify, I suspect, the ways in which Gawker might have obtained revenue from the appearance of the Public Hogan sex tape video.
Yes.
Is there no resource that could be tapped to identify how many individuals who viewed the Hulk Hogan sex tape video in its original iteration clicked from that page to another page within Gawker Media
data that you were referring to?
Absolutely.
And when I started off with you today, one of the things I asked you about when we looked at that clip of Mr. Denton, when we were talking about websites' values being based on traffic. And I think that one of the things Mr. Denton said in that clip was that when he invests in a site, he measures value by interest.
That's correct.
What does that mean?
Well, interest is what drives the traffic, and it really goes back to the first demonstrative we showed with the peak in Google search terms for the word Gawker, the brand Gawker. This is all about generating, ultimately, someday, revenue and profits. But it's about building a brand, building a unique user base, building traffic base to then generate future earnings off of that.
Thank you. No further questions.
Okay, thank you. Do any of our jurors have any questions for Mr. Anderson? All right. Thank you very much.
Thank you. Thank you.
Oh, wait, can I just leave all this? That's all.
We just need to introduce a couple of exhibits that we did not do previously, Your Honor, and we're going to publish two of those to the jury. The first one we're just going to introduce is Plans 238.
Any objection?
And then we're also going to introduce Plans 56 and Plans 62. These were exhibits that were shown to Kevin Blatt during his testimony concerning the fee related to moving a celebrity sex tape.
No objection.
noting the $4.95 trial membership fee. And then plaintiff 62. This is vividceleb.com, and it notes the $4.95 4-day trial membership. And then the last two exhibits just to be introduced. These were excerpts from the defense exhibits that had come up during Mr. Goulet's testimony. And we're going to include those in our list as plaintiffs 592 and 593. In the defense were 229. Randy has this. I provided this.
These were on the first day?
Yes.
Okay. So the ones that we heard that you moved into evidence on day one that were the defendant's objections are renumbered from defendants 229 to plaintiffs 592.
Yes.
And defendants 302 to plaintiffs 593.
Yes.
Okay. Fine. We'll receive this as well. Anything additional?
No, Your Honor. And with that, the plaintiff rests.
All right, thank you very much. So, ladies and gentlemen, the jury, thank you for your attention so far this week. The plaintiff is now arrested. We have some other work that we're going to do, so you all will be excused for the weekend. Please come back. We'll start on Monday at 9 o'clock. So, please remember the rules. Don't do any homework on your own. Don't do any research on your own. Don't about the people or the parties involved in this case. Don't look at any of the news media that's maybe reporting any incidences of this case, and don't talk to anybody about this case. There are parties involved in the case. And with that, you all are excused for the weekend. Have a great weekend. That's all of you, and we'll see you Monday. Thank you all.
I am, Your Honor. So, Your Honor, during the break, we handed you papers that are motion papers. We're going to be getting those on file any moment now. I also handed copies to Mr. Vogt. So we are now, at the close of plaintiff's case, moving for a directed verdict on multiple grounds. And just to give you a roadmap of what we've done here, Your Honor, we filed a motion on behalf of all defendants on all claims on the public concern issue. We filed a motion on behalf of all defendants on each claim except the claim for publication of private facts based on grounds other than the public concern issue. We filed a motion on behalf of all defendants on plaintiff's claim for economic damages and his claim for punitive damages. And then, and this is sort of the new part of this, we have a motion that just applies to Mr. Denton on the grounds that they failed to put evidence on that would, from which a jury could conclude that he actually published the article in question. So I think what makes the most sense, Your Honor, is just to go through the arguments sequentially and maybe give, let's do it one by one. Plaintiff will have an opportunity to respond, and, I'm not going to dwell on all the arguments, just focus on the highlights. So the public concern issue. As is laid out in the jury instructions and as has been established in this case, the public concern issue is dispositive of each of plaintiff's claims. For the publication of private facts claim, it's his burden to show that that the post did not address a matter of public concern. And then on the other claims, at least as laid out in the jury instructions, it's our burden to show that it did relate to matters of public concern. As set forth in the jury instructions, this is the sort of core definition that's provided. A matter of public concern is one that can be fairly considered as relating to any matter of political, social, or other concern to the community, or that is subject to general interest or concern to the public. The evidence the plaintiff,
Concerns to the public.
Subject to general interest and concern to the public. The evidence the plaintiff put on in his case established the following. The sex tape was the subject of extensive public discussion and public interest before Gawker entered the scene and published anything. In addition, Mr. Balayo's sexual and personal life was the subject of extensive public discussion and public interest before Gawker published anything. And this is the last point, Mr. Balayo himself made at least the Hulk Hogan sex life, maybe not the Mr. Balayo sex life, but the Hulk Hogan sex life, and that's what the Gawker post was writing about. He made that a subject of legitimate public interest, talked about it a lot, conceded that when he's Hulk Hogan, that's something that people care about and that he talks about. In addition, Mr. Balayo and Mr. Houston, in their testimony, both conceded that Gawker had a right to publish the article it published, right? To publish the article about the sex tape. Professor Foley, plaintiff's expert on liability, conceded the same, and I think he went further, right? When we showed him the ABC News clips, right, he didn't love it. It wasn't his favorite thing he ever saw, but the sense that I got from his testimony was that that was not a privacy violation. That what ABC News did in making a news judgment that would show that much of the tape and reporting about this lawsuit was a legitimate news judgment. That was my sense of his testimony. So if that's the playing field, right, the question for us on public concern is as follows. Did Gawker go outside the legitimate area of public concern in publishing basically what ABC News didn't publish, which is the 9 seconds of explicit sexual footage on the video? Your Honor, case after case, and we cite these in the motions you read, we cite them earlier in this case as well, case after case is established that a jury is not permitted to apply the public concern test with that level of granularity. They're not allowed to say, well, the whole thing is good, but those 9 seconds, I don't like those. That's simply not how the analysis goes. The two questions that you apply in applying the public concern analysis are as follows. First, did the publication as a whole relate to a matter of public concern? I think it's conceded that it did, at least to the extent that they concede that the article did. Second, and this is the crucial question, if so, did the challenged portion of the publication, in this case the video, bear a substantial nexus to that subject matter? I contend, Your Honor, or we contend, that based on the evidence presented in plaintiff's case, no reasonable jury could conclude that the video did not relate to a matter of legitimate public concern, as the law defines that concept.
That's what?
As the law defines that concept. My anticipation, and they could surprise me, is that what plaintiffs will argue in opposition is that there's a disconnect between what I'm arguing to you here and what A.J. Delario testified to, right? They'll say that we have a legal argument we've crafted about why this was a matter of public concern, but when you asked A.J. Delario, during his videotape deposition, which was played for the jury, he gave a different answer. I'm not sure that's a fair reading of the testimony, Your Honor, but it doesn't matter. The public concern analysis is objective. If you look back at the jury instructions on this issue, there's nothing about motivation, there's nothing about subjective belief, there's nothing about subjective interpretation. It's an objective analysis. You look at what was published, you look at the content and context. Here's an example to flesh this idea out. Suppose someone publishes some whistle-blowing expose about misconduct by the mayor, something like that, right? Clearly that relates to a matter of public concern. There's no doubt about that. That's the core of the First Amendment there. And that would be true even if the reason that person published it was because they hated the mayor, they had some personal animosity toward the mayor. They didn't care whether they were actually informing the public about matters of public concern. They just want to stick it to the mayor. The subjective motivation of the publisher does not matter. The analysis is purely objective, and I would submit to you, based on the facts that were presented in plaintiff's case, that doing that objective analysis, no reasonable jury consistent with the First Amendment could conclude that the video did not relate to a matter of public concern.
Judge, we were just presented with their written motions, which is a rare treat, and a directed verdict. So, I don't think they mentioned the standard for directed verdict, at least in the oral presentation, and I know the Court's familiar with it. Just to remind the Court of it. The Court must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. If there are conflicts in the evidence or different reasonable inferences that may be drawn from the evidence, the issue is factual and must be submitted to the jury. Judge, I read that into the record now because I looked at the other two motions, and one of them is basically just an argument of facts on what was proved and what wasn't. I'm hoping we don't go through that 10-page thing point by point and argue facts today. As to the public concern, notably missing from their brief that obviously has been prepared during the case is any discussion of the Toffaloni case, which has guided the Court's decision-making throughout this process. Equally missing is any discussion about weighing the issue of privacy versus First Amendment rights as reflected in jury instruction number 7, which instructs the jury, and it embodies the Toffaloni standard that we've argued throughout this case, which is the most factually on-point case out of anything we've discussed in the 3 or so years in which we've been arguing these issues. You should take into account, as set forth in that case, the content, context, and form of the material at the time of publication to determine whether it relates to a matter of public concern. The line between the right to privacy and the freedom of the press is drawn where the publication ceases to be the giving of information to which the public is entitled and becomes a morbid and sensational prying into private lives for its own sake, with which a reasonable member of the public with decent standards would say that he or she had no concern. That's the standard, Judge, and there's more than enough evidence at this point without even drawing inferences to go to the jury on that. The fact that Mr. Boulay may have discussed his private life or his personal life to some degree, under no version of Toffaloni gives them the right in a discussion that is purportedly supposed to be about his private life to publish 1 minute and 41 seconds, not 9 seconds, Judge, because there's more to it than that, of lurid, salacious, sexual conduct, sexual video, intercourse, oral sex, etc. The actual article, and I find this issue to be an issue that will be increasingly narrowed as we ultimately get to the jury, doesn't even say what they have been arguing the reason for newsworthiness is. And it's funny how they attempted to just now dismiss Mr. Delario's testimony, because when he was asked what was newsworthy, he said that the video was newsworthy. There was no Hulk Hogan's extramarital affairs, no discussion, oh, well, he's been on TV for years discussing his sexual life. He said it was the video. He found it newsworthy. He found it amusing. As to the ABC News reference, they looped about 2 seconds. They cut it, they cropped it, they left out all of the sexual content. And at the end of the day, Judge, I don't think anything has changed given the presentation of evidence in this case, other than the fact that this looks a lot less newsworthy now than it even did at summary judgment. So we'd ask that on grounds 1, the court deny the motion for directed verdict.
Your Honor, on the Toffoloni decision, we're fine with that case, right? The Toffoloni decision applied exactly the analysis we think applies here, right? You say, what is the matter of legitimate public concern at play here? In our case, it's the sex tape. In the Toffoloni case, it was the life of this woman, Toffoloni. The court then said, well, there's no relationship between a story about the life of this woman and these random nude photos you post that bore no relationship to the underlying article. That's not our case here. The video was integrally connected to the article. The article, as plaintiff has conceded, addressed the matter of public concern. Think about the Toffoloni case in terms of the ABC News thing. You couldn't do what ABC News did with our tape with the Toffoloni decision. You couldn't report about the lawsuit and then put on the same pictures, right? It's an entirely different situation. So we think we're fine with the Toffoloni analysis. We think this case is clearly distinguishable from Toffoloni precisely because here we have an integral relationship between the challenged portion of the publication and what is conceded to be a legitimate area of public concern. Thank you.
In the light most favorable for the non-moving party or the plaintiff, the defendant's motion for directed verdict number 1 in favor of all defendants as to all of the plaintiff's claims will be denied. Mr. Stakier, defendant's motion, you want to take up number 2?
Yes, I do, Your Honor.
So defendant's motion for directed verdict number 2 in favor of all defendants on individual claims and damages. Do you plan to just go through each one?
Right, except for the publication of private facts one. Okay. So, Your Honor, the first claim that I want to discuss is the intrusion upon seclusion claim. As we discussed in connection with the jury instructions, and this is laid out in the Supreme Court's all-state decision, a claim for intrusion upon seclusion requires intrusion by physical or electronic means into an actual physical place, a literal physical place, in which plaintiff had a reasonable expectation of privacy. Here, and I don't think there's a dispute here about the facts, there's no evidence that defendants literally intrude into a physical place. Instead, the evidence established that sitting in New York over 5 years after the original recording took place, and that's the intrusion, the recording, Delario and Gawker published excerpts from the tape. That's not intrusion. For intrusion, you need some sort of literal intrusion into a place. In this case, it would be a recording. In other cases, it was using a telephoto lens, something like that. Plaintiff's evidence makes clear, and he's never disputed, that Bubba Clem was responsible for the recording, Gawker wasn't, and just on that basis, the intrusion claim is out. To the extent that plaintiff wants to argue that what we did is we published something that was in some metaphorical way intrusive, and we did so electronically through the Internet, that's a publication for private facts claim. We can argue about that. That's not an intrusion claim, Your Honor.
Judge, on the intrusion claim, the testimony is clear. I find it interesting that the incredible base of knowledge Gawker claims to have, while at the same time having done nothing to actually confirm where this tape came from, or to ask anybody that was involved in the tape before they published it where it came from. They knew at the time that it was published, or shortly thereafter, that it was surreptitiously taken. It was an electronic tape that came to them anonymously. They literally did nothing to ascertain its veracity, its source, whether it was secretly recorded or not, but ultimately knew that and recorded it and left it, and published it and left it up anyway. The electronic means of them taking an electronically recorded, surreptitiously recorded video and then publishing it through electronic means. Obviously, it's not physical, but that's our response to that. The evidence has been clear on that point.
We'll take your ruling on that.
All right. So on that aspect, we'll be denied.
Next claim, the right of publicity claim, Your Honor. Right of publicity. Sorry. As we discussed in connection with the jury instructions on this claim, to prevail, plaintiff must show that his name and likeness were used without his permission. That's the easy part. Here's the hard part. for a specifically commercial or advertising purpose. The law defines, and we had a bench memo on this, Your Honor, it's the Loft decision, it's the Tyne decision. The law defines a commercial or advertising use in this context as the use of plaintiff's name or likeness to promote a product or service distinct from the publication itself. Plaintiff has not put forth any evidence that Gawker did that. They've not put forth any, or plaintiff has not put forth any evidence that Gawker used the video to promote anything other than Gawker, and promoting Gawker by use of a Gawker story is not a commercial use under the tests. Essentially what they've put before the jury is two things in that area. They've put on evidence, and there's been a lot of evidence that they have tried to suggest this through, that Gawker uses popular stories to grow its readership. Every publication does that, right? The news will report on stories people care about, hoping that people watch the evening news, and maybe they stay and watch some sitcoms, right? That's what every news publication does. That's not a commercial purpose, because nothing distinct from the publication has been promoted. There's also evidence that they put forward that Gawker promoted story about the Hulk Hogan sex tape on places like Facebook and Twitter. Again, every publication does that. That's not a commercial purpose. You're allowed to promote your own publication. And in addition, if that's their argument, then the violation of the right of publicity wouldn't be in the original Gawker post. It'd be in the use of Facebook or Twitter to then promote the Gawker post. They haven't sued us based on Facebook. They haven't sued us based on Twitter. They've just sued us based on the Gawker video. And there's no evidence that the Gawker video was used to promote anything other than Gawker, which is not a commercial purpose. Thank you.
Judge, as a preamble to this and relating back to any of the arguments, we would also adopt all of the positions we previously set forth in the briefings on these issues, because they don't seem to have changed much from some of the dispositive motion stage. So we would adopt all of the law we previously put forward. We've argued this issue already, Judge. We've had a witness get on the stand and talk about the fact that driving traffic is exactly what their business model is, and to drive traffic, even though there may not be an ad on that specific page, that's how they go out and promote separate uses to get advertising dollars. So the idea that there's no evidence in front of the jury, I think we probably put direct quotes from Mr. Denton in, 3 or 4 of them that describes that business model. And so this argument hasn't changed since the previous stage. If anything, again, the evidence has made it more clear, and therefore we'd ask that it be denied.
Your Honor, just one point on that. If it is the case, if it is the law of this country that every time a reporter promotes a story on Twitter or Facebook, that counts as a commercial use for purpose of the right of publicity claim, then every reporter who's covering this case is in trouble, right? We have reporters in the back of there who are writing stories about this case. They're writing stories about me, they're writing stories about you, they're writing stories about Mr. Jekyll, they're writing stories about Mr. Belea, and they're tweeting out those stories. They're promoting them on Twitter. If their theory is adopted, I can sue them. You can sue them, Mr. Jekyll can sue them, Mr. Belea can sue them. We can maybe do it together. That's not the law, right? That would be madness. If you could make out a prima facie case just based on that, there would be the media in the modern age would cease to exist. It has to be to promote a product or service distinct from the publication. A product or service distinct from the publication. Advertising Right Guard, advertising Carnival Cruise, something like that. We have nothing like that in this case, Your Honor.
So on the right of publicity, denied.
Thank you, Your Honor.
Next, intentional infliction of emotional distress.
Very briefly, Your Honor. As you know, in order to establish this claim, plaintiff must show that his emotional stress was severe. You heard testimony that he lost sleep, he lost appetite, he teared up on the set of the Today Show. We lay out these cases in our memo, but the law is pretty clear that to count as severe emotional distress, you need more than that. You need something sort of greater intensity than that. The second point, Your Honor, is that even if the evidence is sufficient to let a jury find that there was severe emotional distress, there's no evidence that that severe emotional stress was actually caused by Gawker, or at least not enough of it, right? Mr. Belea testified that he's never watched the video. He could not have been caused severe emotional stress by content that he's literally not aware of. He has no idea what's in the video. He can't have been caused severe emotional distress by that. In addition, Mr. Belea testified, and you heard this, that he has been suffering distress since the actual sexual encounter was recorded, which was in 2007. He said he's been suffering distress for over 5 years before we published anything. You can't establish causation on severe emotional stress if you're dealing with those kind of facts and evidence, Your Honor. In addition, we maintain that our conduct was not extreme and outrageous. At the very least, I think the public concern issue is a close call. If it's a close call, then the conduct isn't extreme and outrageous. And finally, there's no evidence that the defendants intended to cause Bollea emotional distress. There's evidence that they didn't consider his emotional stress, but that's negligence, Your Honor. That's not malice, an intent to cause him distress. At worst, they didn't think about it, and that doesn't get you the claim, Your Honor.
Well, I mean, I'm at a loss after that one. Judge, the standard is reckless disregard. The idea that they would argue that the publishers or the editors or these people at Gawker didn't act with reckless disregard, it's silly. They literally said they disregarded it. They literally said they didn't consider the effects of what they were doing on Mr. Bollea's personal life. Not only did they do it, Judge, but they did it in a sickening, arrogant manner, as if they're never supposed to think about that. So I can't even really believe they just made that argument. As to the others, Judge, the 5-year argument, Mr. Bollea made it very clear he rehabilitated his life. He got back to a good place and is torn back down. The idea that he had to sit there and watch this video to be the victim of an intentional infliction claim is also, it's an interesting argument, I'll give you that. But I don't think Mr. Bollea, and I think the evidence is abundantly clear, not even inferential, as to the effects of this on him. Looking simply, Judge, to the publicist for TNA Wrestling, Jules Wortman, who testified she saw him crying before he was in character off stage on the Today Show. His own testimony, my life was turned upside down. I couldn't sleep. I couldn't eat. This tore me up. And frankly, Judge, even if you watch the video of Mr. Bollea on Howard Stern and some of the other shows in that time frame, you can see it. I mean, it's visible to a jury or to anyone else what this had done to him. So, as to the emotional distress claim, it should be denied.
We'll take it.
All right, thank you. That motion is denied as to emotional distress.
Okay, moving on to the Florida Security of Communications Act, the Wiretap Act claim. Very briefly, as we've established about this case, the Wiretap Act explicitly provides a good faith defense. We don't think there's been any evidence presented to the jury to suggest that those responsible for publishing believed anything but that they were publishing protected material, right? You heard Mr. Delario testify that he thought the publication was newsworthy. You heard other Gawker witnesses who may not have been involved with the publication say the same thing. There's simply no evidence that they published this in anything but a good faith belief that their conduct was lawful. On the second point on this claim, reasonable expectation of privacy. When we were here a couple weeks ago debating issues under the Wiretap Act, we talked about a concurrence from Justice Overton in the, I'm not going to pronounce this right, the Inquirano decision.
You can spell it.
Inciarano, in which Justice Overton says it's not at all clear, or he says that it's probably the case that outside of your own home, you don't have a reasonable expectation of privacy for purposes of the Wiretap Act. The evidence that has come into this case through plaintiff's case in chief simply underscores that. Mr. Bollea testified that whenever he leaves the house, he's Hulk Hogan, and Hulk Hogan has no privacy. That simply underscores Justice Overton's analysis. In addition, and this was a new fact in this case for us at least, Mr. Bollea testified that before the incident which was recorded, he asked Mr. Clem, "You're not recording this, are you?" Mr. Clem said no. But that shows that at the time, given the circumstances of where he was, what he knew about the house, he had a heightened awareness of the possibility that he could be recorded. That's not a reasonable expectation of privacy, Your Honor.
Judge, from what I'm trying to read this right now, they're not claiming that they didn't knowingly publish a surreptitiously recorded video. I'm just double checking that. So what they're trying to say is the expectation of privacy. Mr. Bollea testified that the only places he felt any sense of comfort were his house and his friend's house. Mr. Clem, he testified, was his best friend at the time. The fact that he asked him, there was a statement that he asked him whether he was recording and he said no, amplifies. You can't infer from that at the DV stage that because he asked him and he said no, I'm not, he should assume he doesn't have an expectation of privacy. If anything, at the DV stage, I would get the inference, but there's direct evidence that he said no anyway. So I'm looking through this. I think I was distracted at the beginning, but I think that's it. Yeah, I mean, if that's their argument, the evidence is clear on that point. So, and Judge, I would also say that they were told in letters that it was surreptitiously recorded, the C&D letters that were sent to them, and they chose to do it anyway. And they did literally no investigation, like most responsible journalists in this world do, to actually find out. They just sat there, they determined they were going to put it out there, they got a letter from Mr. Houston telling them it was surreptitiously done, non-consensual, and they just did it anyway. I mean, literally didn't call one person involved in it. So. And yeah, in the article, I think there's language in which Mr. Valerio actually admits they knew it was secretly recorded. So.
Your Honor, we'll take your ruling.
The court will deny that part of the motion.
We've also moved, as you know, Your Honor, on the issue of economic damages. It's our position that he's only entitled to economic damages for the right of publicity claim. Florida law does not permit, or Florida law only permits recovery for your actual losses. Sorry.
Florida law only permits?
Right. Florida law only permits recovery for the losses associated with the uncompensated use of a plaintiff's name or likeness. I don't think they put on any evidence about their losses. They put on evidence about the value added to Gawker. They put on evidence, I'm not sure where it was going, about membership fees, but there was no evidence about losses. We briefed this issue in connection with the jury instructions. My understanding is you have a different interpretation of Florida law, so if you want to rule now. Or,
Go ahead.
I mean, my
I
understanding.
think he was. Do you want to say in response?
No, it's the
So
same
you're going to
one.
make it record?
Yes.
Of course, we'll deny that.
Yes.
Thank you.
Thank you, Your Honor. Lastly, on to, or at least for all defendants, on to punitive damages. As we discussed in connection with the jury instructions, to establish a entitlement to punitive damages, to put himself in a position where the jury could, at its discretion, award punitive damages, he has to show by clear and convincing evidence that there was intentional misconduct on the part of the Gawker defendants. In this specific context, where we're talking about a publication where public concern is a complete defense, that means they have to show that at the time the defendant subjectively believed that what they were publishing did not relate to a matter of public concern and published it anyway, that they knew that what they were publishing wasn't in the sphere of protected expression. Plaintiff has presented no evidence, let alone clear and convincing evidence, that would permit a jury to draw that conclusion. All the evidence about the posting is that A.J. Delario and every other witness who's talked about it genuinely believed it was a legitimate newsworthy topic, that they confined themselves to publishing those parts of the video that were legitimately newsworthy. And that could be wrong as a matter of law. We think it's correct. But even if it's wrong as a matter of law, they didn't have the subjective mindset necessary to create a predicate entitlement to punitive damages. There was no intentional misconduct. Thank you, Your Honor.
Wow. Judge, if we felt like this was a punitive case before it started, I don't know that I can do justice to how strongly we feel about it being a punitive case now. In Toffoloni, Your Honor, Larry Flint talked to their in-house counsel. That made it into the record. Here, their purported consultation with counsel was protected by attorney-client privilege, which they would not waive. On top of that, so you have that one major distinction as to a good faith belief that it was newsworthy. If you juxtapose that against Mr. Delario's testimony, which was the video was newsworthy, the sex on the video was newsworthy, there was what I find increasingly interesting is every time they have said what newsworthiness was, that is, Mr. Bolaya's extramarital affairs, his discussion publicly of his sex life, and that was their, quote, good faith basis for it, none of it comports with what they actually wrote to justify the video being published. And if you recall, Judge, In Toffaloni, the court made it clear you can't use the text as a pretext to somehow, as a platform just to put a video out. So much worse in this case because there's no story there. It's just a narrative, and that's the relevance of it. And it's a narrative. If you remember Mr. Strockman or Ms. Strockman, the in-house lawyer at the time, wrote the response to Mr. Houston's cease and desist letter, and it had like these 4 reasons as to why it was newsworthy. And it was this age-old, he talks about his extramarital affairs and this and that, none of which shows up in what Mr. Delario wrote, which was predicated on Mr. Delario's decision that the video was newsworthy and they found it interesting and amusing. And that shows their knowledge, that shows their intent. And Judge, we put some bad act evidence in to show you that they actually, in other situations, had taken some time when it wasn't an exclusive Gawker video to condemn others who had invaded privacy. And I don't want to go back through that, the Tumblr article and so forth. But when it comes to Terry Bollea, that's not the luxury we were afforded. Okay? What they did with Mr. Bollea was basically disregard everything they had said about secretly taking sex pictures in the past and how wrong it is and invasive it is, and put it out there with a bunch of jokes and sickening humor and intentionally insulting disregard of any rights that he may have in this world as a human being. It lacks common decency, and I'm frankly even surprised that they put it on their motion for DV. We'd ask that it be denied.
Your Honor, all that matters here, for purposes of this particular part of our motion, is Mr. Delario's subjective mindset. It doesn't matter whether his argument for why it addressed a matter of public concern was as sophisticated as my argument or some argument someone else could make. It's just, all that matters is subjective mindset. And they have put on evidence in this case to suggest that Mr. Delario will publish anything. He's a scoundrel, right? His sense of what is newsworthy is completely unbounded by the sense of common decency. Now, I disagree with that characterization, but if that's a subjective mindset, then there cannot be punitive damages. If A.J. Delario is who they say he is, he's someone who will publish anything, then he didn't have the mindset that would entitle him to an award of punitive damages. He didn't understand his actions to be intentional misconduct because he has a very wide and expansive view of what's newsworthy. And that's all that matters. It may not be the correct one. We think it's close. It may not be as sophisticated as what his lawyers can come up with. But all that matters is a subjective mindset. So they can't have both ways, Your Honor. They can't argue both that this is a guy who will publish anything and this is a guy who won't publish anything but knows that he shouldn't have published what he published here. They can't do it. They can't have it both ways, Your Honor.
So on a DV motion, it will be denied.
Okay.
The jury decide that.
All right. The last little piece of this is particular to Nick Denton. And here we have 2 arguments. The first argument is we don't think there's any basis for liability specifically against Nick Denton. And these are special arguments to him. Nick Denton's company, the company of which he was president and CEO in October 2012, Gawker Media LLC, they're on the hook for whatever Gawker Media LLC publishes. We don't deny that. But Mr. Denton's also been sued in his personal capacity. And if you want to sue him in this personal capacity, you have to show that he actually did the things that you're complaining about in your lawsuit, that he actually published the video. And there's no evidence that's been presented to the jury that would permit the jury to draw that conclusion. What's the evidence that's been presented? There was some testimony at his videotape deposition that was played for the jury where Nick Denton said, well, I don't remember specifically. I've never watched the video. The first time I read the article was a week before my deposition. But I seem to remember some conversation with A.J. Delario at some point. Might have been before the video was posted, might have been after. And my sense of that conversation is that what I would have told him is, don't publish anything gratuitously and get advice of counsel. That's all the testimony about Nick Denton. They put on testimony of 5 other Gawker witnesses, A.J. Delario, Emma Carmichael, John Cook, Scott Kidder, Andrew Gorenstein, none of whom provided an iota of testimony about Nick Denton and his involvement in publication. Under those circumstances, Your Honor, no reasonable jury could find him personally liable for any of the torts, all of which arise out of publication. The second point, Your Honor, is that if the reasonable jury could find that, and I don't think they can, they certainly could not award punitive damages against Mr. Denton. He had no mindset with respect to the publication because he had no role in the publication. His subjective mindset with respect to the publication was he might have had, we don't know the timing for sure, but he might have had a vague awareness that A.J. Delario had gotten a copy of the sex tape. And his advice to him was, don't publish anything that's gratuitous and seek the advice of counsel. So with that record, there's no universe in which a reasonable jury could award punitive damages against him. Thank you, Your Honor.
Yes, Judge. He has a talk with Mr. Delario on the fire escape, and he recalls a degree, to use Mr. Denton's words, of excitement on his part, excitement about the story. He can't specifically remember it, but he would have encouraged him to avoid gratuitous representation of the tape, by which he meant, for instance, putting out the whole tape without making a point. I don't like that, and I would have told him to consult with counsel. Now, we don't get the benefit of the chief executive of the company telling his lieutenant to consult with counsel because that was all protected when they took the privilege. He gets a cease and desist letter afterwards, which Mr. Houston, wrote with this idea of just being a decent human being, some degree of decency as well as the legal letter. And he didn't take it down. Instead, he ratified it. He put his imprimatur on it. He left it out there because he said that the letter was, quote, in his own words, not persuasive. So at that point, he's ratified Delario's conduct. He has put his mark as the chief executive of the company on this, and he had knowledge before it went out there. And frankly, Judge, they kind of make our point for us in the sense that the person who's driving the ship there doesn't do any of the things a responsible executive is supposed to do to prevent these kind of situations. And when it went bad, and the lawsuit hits in October 2012, mysteriously, Delario goes on a sabbatical, and then in January, I think 2013, they cut him loose. They cut this guy loose and give him $500,000 that Mr. Delario testified Mr. Denton invested in his new company, Ratter. And Judge, he knew it before. He did nothing to stop it. He had an opportunity afterwards. He ratified it. He wouldn't respond to the cease and desist in even a remotely responsible way. And frankly, from the standpoint of omissive conduct, Judge, he didn't even look at the tape before he authorized Delario to go out there and send it out into the world. And we think there's plenty, again, of direct evidence, let alone inferential evidence. So.
2 points, Your Honor. You cannot hold an editor or publisher liable just on the theory that they didn't stop the thing from being published. Right? If that was the case, then editors and publishers would be personally liable for everything that gets past the goalie. That's not the law, right? Simply failing to stop something from publishing isn't a sufficient act for ground liability for an intentional tort. It's not a negligence case. There's no evidence that Mr. Denton actually played a role in the publication. That's the need for liability. Second point, Your Honor. Mr. Turkel talked a lot about Mr. Denton's response to Mr. Houston's cease and desist letter. That's irrelevant, right? The tort is the original publication. There is no tort for keeping a publication on the Internet. In fact, and we briefed this, Your Honor, in connection with the jury instructions, the single publication rule in Florida prevents that sort of theory of liability. It says that when a tort arises out of an act of publication, the claim accrues upon the moment of publication. You leave it up there for years, it's not a new tort. The tort accrues at the moment of publication, and there simply isn't evidence that Nick Denton personally was involved in the publication. Their theory is just an omission theory, and that can't ground liability for intentional tort, Your Honor.
Defendant's motion for directed verdict number 3 in favor of Mr. Denton as to all of plaintiff's claims is denied. Okay. So, any other motions for the defense?
Yeah, nothing else.
No. Okay. So, I have a few things then that we need to at least schedule. I have now received the Steele's, the news media intervener's motion to vacate the unconstitutional prior restraining order barring release of jurors' names, and Mr. O'Brien's motion to quash the subpoena for trial. So, that being said, it seems to me that we need to schedule it at a point. Ms. Steele says that she can be available. I don't know what Mr. O'Brien's schedule is. Ms. Steele says she's available anytime.
I was just talking to Mr. Sullivan with the idea that maybe we set aside Monday morning for hearing those two motions. If he's okay starting this case in chief, either late Monday or right after lunch Monday.
So, I know Ms. Steele's schedule. She's told she's available anytime. How about Mr. O'Brien? You write down the schedule?
The only thing I knew that he told me was he had a status conference in Fort Myers Federal Court that he could attend by phone to make it here. I think it was set at 9:30. If we did Ms. Steele's motion first, perhaps, then I don't.
How about 8:30 on Monday?
Oh, before the stand? Yeah, that's fine.
Before the jurors all come. Does anyone anticipate, well, two things. On the Mr. Clem's motion, I know both sides were anticipating the motion being filed. I don't know if either side has had any opportunity to do memorandums of law or anything for the court.
We are in the process of preparing a memorandum of law for the court. We would very much like to file that so you have the benefit of that.
Well, if you file it, I won't see it for days, so probably you could just perhaps email us the copies.
We weren't going to prepare them, but
We thought it would be prudent to give you the benefit of the law. So we will, in fact, file something.
we'll cobble one together after we see the motion. And again, we've discussed the motion in some detail with the other side. I think there's some general agreements on a lot of the points of law, with one that we may need a ruling on that'll trigger the rest of it. And I think the bigger picture isn't going to be legally where the issues are. I think it's ultimately going to be how we handle it practically. So.
Okay, so can someone, like you, Mr. Trickell,
Yes.
tell Mr. O'Brien Monday at 8:30?
Yes, you guys can do it.
It's fine.
Yeah, that's fine.
And then we'll tell Ms. Steele as well, and we'll go from there on those two. All right, it sounds like you guys are going to get much of a weekend. You're going to be free.
The weekend will mean nothing. We're going to change the dress code, Your Honor. But a welcome.
And location. Anything else?
Yes, Judge, actually I have something. Within the two exhibits from Monday, the two defense exhibits.
Yes.
You have the marks 593 and 592.
Yes.
Actually, the plaintiff's last exhibit is 616. So these would have to be 617 and 618.
So Mr. Boat, sounds like the numbers are a little off.
I think so. We must have missed the list.
Okay, so 592, which was the defendant's 229, should be what number, Mr. Hall?
Should be 617.
617. And then that would be defendant's 302 that was made to plaintiff's 593 should be 618. Is that correct, Mr. Hall?
Yes, Judge.
Thank you.
Thank you.
Thank you for catching that.
Thanks, Fran.
All right. Mr. Sullivan?
No, ma'am.
Anything else?
Nothing else, Judge. That's it.
All right, great. Well, thanks for talking. A very good week. Everybody's maintained their professionalism. I greatly appreciate it.